that the National Assembly may not designate Dr. Hlophe to serve on the JSC. That is a mistake. The freedom under law prayers are at 0, 2, and 1. And you see that they go no further than to ask for the designation to be set aside in the first place.
That's what I made you all mindful of the joint vote. I see Council for the National Assembly probably relying on that joint view.
No, we don't seek that consequential relief. The defense of the Mdntv is always more aggressive than we are.
Is that his nature? Is he more aggressive?
It doesn't affect the argument because the applicants, and particularly Corruption Watch, are seeking more than simply security.
Thank you.
At 3 hours. Thank you. Mr. Butlander this morning touched a sensitive matter for me personally when he referred to tax. And he suggested that the argument we make is that there can be a dartboard and we will just throw against the dartboard and anybody there should become a speaker. I enjoy that game, the dartboard, so I'm a bit offended that Mr. Butlander decided to use that as a start from the record. I appreciate that. That too is helpful, a helpful response. Calms me down a little bit. But it's now clear what these applicants are looking for. It's very clear. They are looking for something that is not in the Constitution, that is not sanctioned by the Constitution. They are looking for a process in terms of which a judge who is removed from office suffers what we refer to as collateral consequences. In other words, we are not satisfied with the removal of a judge from office. And let me describe what that removal looks like. Someone who has worked as a judge for 28 years, going to 30, is removed from office in the manner in which Judge President or Dr. Hlophe was removed. It span over a period of about 13 years to finally get him removed from office. There is nothing as painful and as humiliating as to be stripped of the honor of the office of a judge. If there is any, it's actually death penalty of a judge when they derobe you. In my faith, you only get derobed when you are dead, if you're a pastor. And they declare that because you are dead now, they're going to remove your robe. So the impeachment process itself and the decision to remove a judge from office is a sanction. However one wants to pitch it, you are removed as a consequence of a finding that you are either incompetent or you've committed gross misconduct, or that you suffer from incapacity. That's what 177 says. So let's demystify this issue, that when you get removed from office, it is not sanctioned. That's what the DA and the Corruption Watch would like to have, that when a judge is removed, it's not enough that he's removed from the office. They don't consider it a sanction, but it is a sanction. And I'll refer the court to the provisions the Judicial Services Act, which deal with sanction at some point somewhere in the Judicial Services Act, deals with sanctions that are applicable to non-impeachable offences, though, but not the impeachment offence. So it's a mischaracterization of the consequence of a finding that a judge has committed any of the three issues that are raised in 177. Mischaracterization to say that it is not a sanction. It is not a sanction in the sense of a criminal sanction, but it's definitely a sanction. Judge President Hlophe will not exercise judicial authority again, forever.
You mean Dr. Hlophe?
Dr. Hlophe, sorry, I apologize. Dr. Hlophe will never exercise judicial authority again, forever. Unless obviously he succeeds in his review applications. And he elects, if he succeeds, to come back to the bench. What is being suggested here just also shows the alarmist nature of the submissions that we were listening to this morning. Wow! He was found guilty of gross judicial misconduct and therefore unsuitable to perform JSC non-judicial functions. And that will take me to addressing what exactly does the JSC do and what is the role of the National Assembly in relation to the JSC and the JSC processes of Section 177, in which the JSC is similarly involved together with the National Assembly. So I want to be very simple, like my learned friend, I think it was for the FUL, said, this case is simple. And it's being clothed with a complicated narrative. But part of it is that, there are certain organizations which have made a sport of attacking Hlophe whenever he says something in public. That's common knowledge. They'll take him to court. In fact, before this court, they've threatened that in the event that he's nominated by his party, and the National Assembly, in its wisdom, designate him as a member of the JSC, you haven't seen the end of the day. So they'll come back again. Because for them, that's a sport. That's like, it's become almost a ritual of an oppressive ritual. Hlophe must not raise his voice, he must not be heard, he must not be seen, he must just wallow in disgrace. Some of them are quite happy to call him a disgraced judge. Yes, he may be a disgraced judge, but that's where it ends. There are no consequences beyond being disgraced. The fact that they call him a disgraced judge tells you that this idea, this notion that when a judge is removed from office, that's not enough. And in fact, the DA says in its conclusion, it is a startling proposition that there are no collateral consequences to removal of a judge for gross misconduct. And then it concludes that there are and should be profound consequences for gross misconduct by judicial officers. One ineluctable that word consequence is that judges removed for gross misconduct should not decide on the appointment of new judges. And the false narrative that's been peddled here is that when a person exercises the power in the Judicial Services Commission, they are exercising a judicial power. They are not. They are simply conducting an interview. And they are not making a decision, they make recommendations. The person who makes a decision is the president of the country. That is the person who appoints judges.
Is it not upon the recommendation?
It is upon the recommendation. So the primary function of the JSC is recommendation. Now, for somebody to suggest that you need a holy angel to sit in the JSC in order to perform the functions of the JSC is absurd. It is totally absurd. I'll show why it is absurd. And this is where I want to begin. Now, if we look at section 47, which relates to the designation, the membership of the JSC, the membership of the National Assembly, it tells you who is eligible to be a member. And part of what it says is section 47, 1C, I'll start there. It excludes unrehabilitated insolvents. So if you're unrehabilitated insolvent, you can't be a member of the National Assembly. Then it says anyone declared to be of unsound mind by a court of the Republic. If there's a judicial order that says your mind is not okay, then you can't be a member of the National Assembly. Anyone who, after this section took effect, is convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic outside, if the conduct consisting of the offence would have been an offence in the Republic, but not one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time for an appeal has expired. A disqualification under this paragraph ends 5 years after the sentence has been completed. So what it tells us is this. Every person who does not fall within the exclusions of 47 is qualified to be a member of the National Assembly. So you could be a person with a criminal record, but you are outside the 5 years. And we know there are many of them that are sitting in Parliament that had previous records of crime. Now, what this says is this. When the Constitution has given, when a person has become a member of the National Assembly, and there's no challenge to that membership of the National Assembly because it does not fall within the exclusions, of which Dr. Hlophe is one of them. That means he's a member of the National Assembly in good standing. Right? Now, a suggestion is made by Mr. Badlender that that we submit, or the effect of our submission is that we're not looking for suitability. That's a false argument about our argument. It's incorrect it's a distortion of our argument. The correct argument is this one. When someone is a member, the only qualification for membership of under 1781H is member of the National Assembly. That's the only qualification. There's no other qualification we are aware of. There is no additional qualification that once you are a member of the National Assembly, there ought to be other skills, other vetting processes that you have to go through in order to qualify for the activities that you are enjoined to perform as a member of the National Assembly, as a member of the National Assembly. So a clear reading of 1781H, a honest reading of that provision, is that when the National Assembly is designating its members, there is a presumption that every member in that National Assembly, irrespective of their experience, irrespective of where they come from, irrespective of their qualifications, academic or otherwise, a matriculant who happens to be a member of the National Assembly is entitled to the process of 1781H. And according to the theory of the applicants, a matriculant who has never been in a law class, has never studied law, has never been in a courtroom, has never performed any JSC functions as Dr. Hlophe has got a matric certificate. And some of the prof says you don't actually need a matric certificate. So but I'll stick to the matric certificate. They say that person is presumed to be fit to serve in the JSC if he's elected, because obviously he was not removed as a judge. Could never be a judge as a matriculant. I'm listening, Judge.
Mr. Masudu, tell me if you agree with me that there's actually certain ethical standards those tasked with the selection of judges must at least subscribe to the process. You just mentioned the issue of it's well and good that you may have someone of the high academic standards that is commendable in the JSC. But I just want you to, owing to the prevailing circumstances surrounding Dr. Hlophe, in the sense that reasons that led to his impeachment, as the courts have already pronounced themselves on the issue, that the judicial selection process would require an individual with that the judicial selection process will then have to prioritize integrity, impartiality, and public confidence, which, as argued by the applicants earlier, that it could be undermined if a person of Dr. Hlophe's caliber is tasked with the duty of selecting judges. I'm making this comment and I want to hear from what you say.
Thank you, AJP. There is this constant refrain from the applicants that because he's a disgraced judge, he is unfit to be a member of the JSC. But they miss one point, and I'm assuming, Justice Mbele, that your question is premised on the fact that the answer must be anchored entirely on the Constitution. Whether one likes what the Constitution says or not, that's a different issue. What one dreams about, how the Constitution should read, that's another issue. I'm going to base entirely on what the Constitution says. The Constitution says that if you are a member of the National Assembly, you fall within the scope of Section 178, 1H. That's what it says. It adds no flavor to it. There is no flavor into that Constitution. One can read in that flavor, but I'll look at what that reading does, what violence it does to the provision of Section 178. And I was trying to develop my argument to deal with that aspect later on, the aspect of whether whether Dr. Hlophe is in fact demonstrably unfit, as it's suggested as is alleged by the applicants. And here was my contention is that let's look at the Constitution itself, because that's what binds us. This is the document that we're all bound by, and it tells us who qualifies to be nominated, to be designated by the JSC. Nobody else does that. There are two things that are completely incontrovertible about the statement I'm going to make. The first one, it is for the National Assembly to designate its members. Nobody else. Interlopers can have views about what the National Assembly has done, but it is for the National Assembly using its own rules and its own conventions and own practices to designate who amongst them as members of the National Assembly must be designated as the 6 members that will represent the JSC. And here is the problem with the theory of the applicants. Dr. Hlophe can sit in the Portfolio Committee on Justice to decide a finding of the JSC that a judge suffers from incapacity or misconduct or incompetence. He can sit there. They don't have a problem. I hope they don't have a problem with it. He can sit. But also, under Section 177(1)(b), Dr. Hlophe is part of the National Assembly, can stand up during a debate where a judge is being, where the National Assembly is considering a resolution to remove a judge. Because remember, the JSC does not remove a judge. The JSC merely makes a finding. The body that passes a resolution for the removal of a judge is the National Assembly. Their argument, according to their theory, Dr. Hlophe can act as a member of the National Assembly, stand up, make a statement, contribute to the debate, try and influence his colleagues on where the resolution must go, whether to remove a judge or not to remove a judge. He's competent to do that. But they say he can't sit to ask a judge or to ask a candidate for judicial office questions about their suitability. A function he has performed as a judge president before, a function he well knows very well. They say he because he was found to have been is found guilty of misconduct. Now, I mean, it can't apply. It can't. The theory of the applicants cannot be right where the National Assembly is considering the removal of a judge, because the removal of a judge directly impacts on Section 165(3) or 165(4). Directly impacts there. It speaks to the core of judicial independence. Nothing is as wicked as unconstitutionally removing a judge from office. It violates judicial independence to do that. Right? So, Dr. Hlophe can participate in that process of removal. But, and if he does, it would be extraordinary to come to this court and to say he should not debate, should not vote, he should not try and influence others on how to vote because he was an impeached judge, as they would like to call him. So, all I'm saying is this: it does not undermine judicial independence for Dr. Hlophe to be involved in the removal of a judge. Why does it undermine judicial independence? To perform a function that involves interviews and in the middle of 23 other members. 23 members are involved. It's the only one who is involved. Why does it threaten judicial independence when he asks questions about the suitability of a judge? And I will also speak about his experience, how relevant is, how important his experience is as a so-called impeached judge to that particular process. How necessary that experience is. So,
I thought you said metric is more than enough.
The what?
I thought you said metric is more than enough.
Yeah, no. But when I was trying to develop my metric theory, then I got to ask the question which required me to deviate a little bit from the metric theory. But let me go back to the metric theory, because that is the theory that...
I've said, I beg your pardon, but if we accept, no one seems to be arguing otherwise. He has a PhD in law. He has been a judge for his law. He has been a judge president. But since then, he has seems to be defrocked, as it were. The issue of his qualification and experience, is it relevant for persons? The foremost person before us.
No, it's relevant for how you interrogate rationality, the rationality of the decision that the applicants are attacking.
So before we go there, can I just ask, let me just understand the submission. Is it accepted that there's a difference between a parliamentary committee and a one, and then I'm not call it the entity, but the organ that is established in terms of the Constitution, Section 7, 8 of the Constitution of the JSC. Is there no difference between the two?
No, with respect, the only difference is that of function. But they both perform constitutional responsibilities.
At the moment, one performs constitutional responsibilities. Then, of course, you bring in the entire constitutional framework and the values and the norms that we accept as foundational to our constitutional organization. So is the submission that none of that impacts on the functions of the JSC and on the suitability of people who are appointed to the JSC?
Let me try and answer that question in the following way, Justice Boswell. First is this. The National Assembly participates in the JSC through its 6 members. So they designate 6 of their members who can participate in the JSC. And as we say, their only qualifications as far as we're concerned, in terms of the Constitution, is that they must be members of the National Assembly. 3 of whom must be members of the opposition. That's what Section 178(1)(h) says, right? So when the National Assembly is wanting to give support to the JSC, so that the JSC is able to perform its constitutional obligations as a properly constituted body, the National Assembly must produce 6 of its members to go and sit in the JSC. And you will see that even the JSC, the Section 178 provision, also excludes members of the National Assembly and Provincial National Council of Provinces from sitting in certain deliberations of the JSC. So there is a clear delineation of responsibility where members of the National Assembly will not be required when the JSC is considering certain aspects of its functions.
If you look at 165 falls, that's the one that was referred to many times today. The organs of state must ensure the independence, impartiality, dignity, and accessibility and effectiveness of the court. Now, how does the organs of state, such as the National Assembly, do this by appointing someone to the process that has been found to be of questionable?
No, you can say it, Judge. Don't worry. He's here in court. He will understand it.
He was impeached. We know that, and
yes.
we know the reasons why he has been.
Yes, it was gross misconduct. Yes.
So how does appointing such a person to the JSC promote the impartiality, the dignity, the effectiveness of the judicial system?
The same question one must ask. How does someone who supported the apartheid legal system, apartheid legal system, apartheid having been declared a crime against humanity, how does the National Assembly promote judicial independence? By fielding someone with that kind of history?
That's a very valid question, but that's not before us.
No. You've asked me to answer the question, how does this impeachment promote judicial independence? And I'm asking you to disabuse yourself of this notion that impeachment of a judge disqualifies them from acting responsibly.
No, but it's not only the impeachment, it's the conduct.
Which conduct?
Well,
let me address the post-impeachment conduct. He's not a judge. He's a politician. He's a politician. When he was a judge, there was only one unfortunate event that landed him into trouble. And we will know if the public were told the honest truth, not this cooked up narrative that is not contained in truth. The first JSC that dealt with the allegations of misconduct against Hlophe acquitted him. The public will know that when they are being told. If the yardstick is the public, they will be told. Oh yeah, by the way, in 2008, in a very long judgment, the JSC acquitted Dr. Hlophe of the same allegations that the other JSC the JSC of 2008 found acquitted Hlophe of the allegations of misconduct, which the next JSC.
But we have since passed that, Mr. Masuku. We have since passed that. We are where we are now because eventually the JSC found him guilty of
No, but the truth of the matter, and you must factor that in your assessment of rationality question. He was found guilty by the JSC by a majority of members. There was a disagreement. Yes. And that must tell you on the question of whether this conduct is constitute gross misconduct or not. Even amongst the bodies, the body that must decide that question, there is disagreement. Even amongst the bodies, the body itself that must decide that question, there was disagreement on it. So what I'm saying is this: that when you try and adopt an alarmist position that suggests that this impeachment closes the door for Hlophe in life, that's an unfortunate position to adopt. It's an unfortunate position because it's not consonant with our constitution. Our constitution does not close the door for a judge who has been removed from office. And one must look at 177. 177 does not tell you that an impeached judge, a judge being removed from judicial office for any of the three reasons, suffers, is closed outside, and he cannot be a member of the National Assembly. And quite correctly, the applicants see the light in that respect, and they do not challenge the lawfulness of his membership. Question done.
I really try not to interfere with your line of approach, formulating approach. But there's one thing that I don't think can point avoid, and that is the judgment of the Constitutional Court in paragraph 37 of the Susan. Because there the Constitutional Court has spoken in relation to designation. How to get past that in interpreting whichever provisions you refer to?
No, I mean,
how to get past that paragraph?
Yes, you have to decide the question of suitably qualified. The question of suitably qualified is simply answered by one issue. Suitably qualified is you are a member of the National Assembly. That's it. There's no any other qualifier, and that's where you get into trouble with trying to split the duties that are engaged in 178 1H outside the membership of the National Assembly.
In essence, section 47. Am I right?
Yes.
That's all I wanted to do.
But also perhaps to buttress my point. I gave an example of a teacher was removed from his job or her job because of an act of dishonesty 6 years ago, now a member of the National Assembly. He gets nominated by his party to be a member of the JSC. Are we going to see the same application coming up here? That this is a teacher who was removed from his position for an act of dishonesty, and therefore, why did the JSC, the National Assembly, adopt a special procedure for that teacher? We've got to say somebody is a carpenter who is now a member of the National Assembly, who has been nominated by his party to become a member of the JSC. Are we going to find similar arguments that this person knows nothing about the JSC work and cannot be a suitable person for the JSC? Members of Parliament are not all lawyers. Members of Parliament they come from very life experiences. Some of them, as I said when I was answering just so, some of them come with a history of the past. And are we going to open that door and say, well, because of your past, can we just find out whether you can perform a function to appoint a judge who is suitably qualified for our constitutional democracy? That is why the Constitution is very clear. That only qualification you need in order to be one of the 6 members is that you must be a member of the National Assembly. And that's when you assess the reasonableness of the lawfulness of the decision of the National Assembly. Ask yourself this question. 1781A(H) says 6 members must be members of the National Assembly. Are these 6 members of the National Assembly? The answer is yes. Are 3 of those members of the opposition? The answer is yes. Have you complied with section 1781H? The answer is yes. But here is the difference, and this is where we might find each other with the applicants. Once a member of the National Assembly has been appointed to the JSC, it is that member of the National Assembly that must perform in accordance with the role that the JSC is established for. That is the member that must go into the JSC and perform those functions that the JSC is established for. So with respect, this case, as I said, would be easy if we just we paid loyalty to the Constitution and we interpreted Section 1781H on its terms. Are you a member of Parliament? Yes, I am. Are you a member of the opposition? Yes, I am actually the leader of the opposition. Do you fit in 1781H? Yes, I do. What they want, the applicants, I say, when I say they, is that the question must go further than that. What is your history? Tell us. Did you support apartheid? No, I did not support apartheid. Or did you support, were you impeached as a judge? Yes, I was. Or were you fired from your job as a CEO of a reputable company? Yes, I was fired. What was it? It was corruption. No, you can't go in there. We can't do that to the work of the National Assembly. There is a presumption we must extend, and the court must extend that presumption to members of the National Assembly, that they are there to perform a constitutional function, and they will do it in accordance with their oath of office. They are not there. So, no one will quibble with the fact that there is a general of the former South African Defence Force now serving in the JSC. No one will quibble with that. As long as the question that you ask is the correct one and it's consonant with the provision of the Constitution. Is he a member of the Parliament? Yes. Is he a member of the opposition? Yes. Or is she a member of Parliament? Is she and if the answer is yes, then he's appointed. Don't get into the assumptions that are dragged into this matter. Assumptions that will become problematic for the relief that you are being asked to seek. What we are asking you to do is to pull the whole rug down of the procedure that was used by the National Assembly to designate the one member of the National Assembly. So what they are asking is this. As far as these 5 members are concerned, there are no questions asked about their suitability. No questions asked. Just one member. And it's based on what? His history. And one must ask the question, is the National Assembly not bound by the Constitution itself? Can it pass a law that says if you are a member of the judiciary and you are removed from office, you don't fall within section 1781H? So even if your party nominates you and wants you to represent, to be designated by the National Assembly, you cannot be designated by the National Assembly, even if the majority of members of the National Assembly believe that you could add value to the process of the JSC. And exactly what does the JSC do? That should horrify the applicants. The Constitution tells us what the JSC does. One looks at 178. 1784 says the judicial service, the powers and functions assigned to it in the Constitution and national legislation. So one must go to the JSC Act to find out what the JSC does. But here is another function in 5, section 1785. The Judicial Service Commission may advise the national government on any matter relating to the judiciary or the administration of justice. Let's just stop there. Why is it inimical to judicial independence in section 165 for one member of the 6 members that are nominated or designated by the National Assembly, who happens to have been a judge before, to advise national government on any matter relating to the judiciary or the administration of justice?
They are excluded without the members dedicated in terms of section 1H and R.
Yeah, okay, no, that's correct. So let me ask the same question I asked. Why is judicial independence threatened when they are excluded? So Dr. Hlophe won't sit when the National Assembly, when the JSC is advising national government on any matter relating to the judiciary or the administration of justice. He won't be sitting there. And then the JSC may determine its own procedure, but decisions of the Commission must be supported by a majority of its decision. By its very nature, it presupposes that there will be, the JSC may well be split, as it was in the case of Dr. Hlophe. But the majority decision is what passed. So are we going to say that a person who dissented in the finding against Dr. Hlophe of misconduct cannot be designated, should not be designated as a member of the National Assembly by the JSC, because that person supported Dr. Hlophe's in his impeachment proceedings. It's a member of 4 members of the JSC sat together. They said no, but this is not judicial misconduct. In fact, even considering that prior JSC had said no, this is not judicial misconduct. I'm saying if a person, if it's as abhorrent as is presented by these applicants, that finding against Dr. Hlophe of gross misconduct should not disqualify him. I'm asking this question. What about the person who sits in the JSC, says, no, I don't agree that his conduct is gross misconduct? Is that person qualified? Is that person acting in accordance with section 165(4)? So it's a red, this section 165 argument in respect of, is a red herring. It's really an unimpressive attempt to devalue the experience Dr. Hlophe has with the JSC, its work, non-judicial work. It doesn't require rocket science. You're interviewing judges and recommending them for appointment. And you're not doing that alone. And here is the point. These 6 members do not perform these functions alone. They are not always in agreement when they perform those functions in the JSC. They may differ on issues that pertain to, that are relevant to the suitability of this candidate and the suitability of that country. So it's just an impressive interpretation of 178 1H to suggest that because of the impeachment history, the National Assembly's decision to designate that individual is in fact wrong. And here is the issue that is very important. When Dr. Hlophe was removed from the bench, as I said earlier on, one thing he cannot do is perform judicial functions. When he sits in the JSC, he's not performing judicial functions.
He decides who becomes.
That's not a judicial function.
It doesn't.
That's not a judicial function. It requires no more than what anybody sitting here can observe. If a candidate for appointment performs badly, it doesn't take a rocket scientist or a high ethical value to discern a specific quality that this person has. It's a simple process. You're asked in accordance with your with your representation in the JSC. You are asked about your experience. You are asked about your judicial philosophy. You are asked about this. And then there's a debate within the JSC about the suitability of your candidacy. And members of the JSC are not always in agreement about candidates.
He says he's going to promote with fellow JSC members armatic characteristics. The very things that led him to be deformed, which was frowned down upon. That's what he's going to promote.
Yeah.
JSC. That's what he says.
In fact, you know, that I was waiting for the opportunity.
Am I wrong? Is that
Yes, you're completely wrong. You have been misinformed, Judge.
I beg your pardon?
You have been misinformed by the applicants.
Oh.
Because it's a submission that was made by Mr. Badlander. Completely erroneous submission, which is also supported by the FUL. Completely false submission. Here's what Dr. Hlophe says, and you'll find it in his affidavit.
Yes, I thought I picked it up somewhere. If I misread it, you must tell me. Remember, there were 12,000 pages to go.
Yes, no, that's I understand,
That's
Judge.
busy.
This is so it's on page 38-33.
Mr. Muila, can you invite us? Someone who can invite us. So that we don't have to worry about paging through all these pages. It's a long day already. That is if Mr. Bishop is taking the course.
He's not assistant Dr.
I'm not sure, Judge. Should I wait until you are assisted?
No, we are there.
Right. So here is what this false narrative that is being paraded now by FUL, unsurprisingly. And I say unsurprisingly because they've litigated against Hlophe at every point in 10. So there is a program, a project. This is a project of theirs. And now joined by Corruption Watch. They are the recent recruits into the attacks on Dr. Hlophe. Here is what Dr. Hlophe says. I cherish an independent judiciary and intend to work to ensure that that independence, which powered my work as a judicial officer, lasts beyond the edges. Because I was an independent judge and did not conform to traditions of control, I developed a free spirit in which I was open with my views on matters of law. I demystified what it means to be a judge of the people and from the people. I never held myself to the position of being an untouchable. I accept that judges are human too and can make errors. One of the things that I realized that I needed to do in order to perform my judicial functions effectively was to learn how to speak and write in Afrikaans, because I quickly realized that it would enable me to perform my duties with sensitivity to the culture of the Western Cape. I know of no white judge that, with intention to improve their capacity to perform judicial work, learned isiXhosa, a language of the majority of Africans in the Western Cape. When I was removed from office, I'm possibly the only judge who deliberately and intentionally learned a new language for the purpose of performing my duties. And I could conduct a full trial in Afrikaans without the need of an interpreter. To be sure, I was involved in a few controversies, some directly tied in with my passion for justice and respect for our Constitution. It was that passion for justice and respect for our Constitution that actuated me into writing the report about racism in the judiciary. Charity begins at home. Without a transformed judiciary willing to eradicate racism and sexism in all its manifestations, the broader national transformation agenda is imperiled. Merely being black and claiming to be for transformation is not in itself sufficient. A truly transforming judiciary would speak out against racism and injustice. I'm the only judge openly opposed racially offensive tendencies that bedeviled the Western Cape High Court. That is what earned me the attention of these organizations, FUL and now Corruption Watch, who today pursue me with unflinching hatred. And then he quotes his friend. What his friend says is very kind. I mean, it's the nicest thing a person can say about a man who is vilified as much as Hlophe is. I won't read it. But here's what he says in 16. While the experience of impeachment was deeply hurtful, I do not intend to wallow in the pit. I have learned to live with little and I've learned to live with much. Much was given to me and I intend to dedicate my last years of life serving my country with distinction and unflinching devotion. I do not expect accolades from organizations like the DA, Corruption Watch, and the Fool. I differ fundamentally with the manner in which they seek to treat me and millions of our citizens with the terror of their bigotry. I will not be reduced to an appendage of their ideological fantasies. I served my time as a judge, and I would not have chosen to bow out as it happened. I intend to continue to promote judicial independence and the integrity of the judicial office for my country's sake. If it is not for my children's sake. I will not be cowed into silence by these organizations who make it their sport to scheme, lie, and plot my downfall. That is what qualifies me to be a member of the JSC, my extensive experience and contribution to the transformation of the judiciary. This is what makes these vindictive applicants vengeful. The reality that I will continue to insist on the transformation of the judiciary, because that prospect drives fear that those they revere, who they wish to see as judges, but are not fit for our constitutional purpose of transformation, will be asked to justify where they should be accorded the honor of being judges for our constitutional democracy. They wish to protect their candidates from the scrutiny that they know I will bring in the JSC. When I was removed from office, I saw cruelty and insensitivity of officialdom. I have been there in the pit of the hell of hatred, and I know how to survive. I lost my benefits, and no official ever said to reflect whether summarily withdrawing my benefits was lawful in light of the Constitution. Okay, then perhaps I should go to a paragraph where he talks about that he will ensure that judges who are appointed are not afraid.
I was hoping you would.
That's what I'm trying. I just said that, Judge Ndau. I hope you heard me say that.
That's what I heard.
Yes.
I'm trying to find that.
Yeah, but I've read something that tells you. Sorry. Right, it's paragraph 20. Thank you. Just. In paragraph 20 it says, I intend to ensure that no other judge is subjected to these unconstitutional acts of a vindictive political tyranny. I intend to ensure that judges are treated with dignity and held in high regard in return for the work that they do to ensure that we are safe from the excesses of the powerful. My new role gives me another opportunity to continue with the mission I accomplished in the Western Cape. Full transformation of the judiciary to ensure that it reflects the true identity of South Africa as a constitutional democracy. Now, if one reads that paragraph, where does it say he wants to encourage people to do wrong things? There is no way. It's a manufactured lie that he says he wants to encourage people to commit judicial misconduct, the nature of which saw him leave the bench. All he says when he talks about how he's, and remember, Dr. Hlophe has not accepted that what he did was wrong. Still challenges the constitutionality of his removal. He does not accept that a judge having a conversation in chambers with another judge is necessarily wrong.
In other words, it's unapologetic.
No, he's unapologetic of what happened. That's why he went full defense against in all the JSC processes, because he tells you that as a judge of significant years of experience, he has been part of conversation with other judges where they speak about judgments that they're writing. Nowhere are you going to find the kind of allegation made by these applicants, that he says he wants to coach, he wants to promote unethical behavior. It's a complete lie. But it's unsurprising, as I said, because they have made it their mission to devalue who he is as a human being. I mean, what interest would he have to promote unethical behavior in the judiciary, having worked and sustained his life through the judiciary? But here are the paragraphs I've referred to you, where he makes it very clear that this is what he intends to do with the power he has as a member of the JSC. There will be another paragraph to my recollection where he talks about the fact that he doesn't accept that a judge having a conversation with another judge necessarily brings misconduct.
I think that's in the back of my mind as well.
Yeah, no, there is somewhere where he says that. But the context he gives is not what you're being told by these applicants. It's not what you're being told by these applicants. The context is what I've just read to you. Someone who says, I'm in a new role, I accept my fate, I'm in a new role, I'm challenging this impeachment of me because I think they were wrong. And if it becomes a template of removal of judges, I'm sorry, judges will be like they will live like they'll be like in a nunnery or in a monk, where there are no discussions amongst judges, where the presumption that it doesn't matter what you hear from the news about your case, which is going to be all over the news. It doesn't matter what the news say. You're focused on what matters, what you have read, what the evidence is. That presumption of judicial independence is what makes this whole case of his impeachment very dangerous for judges. Because judges talk amongst themselves. They talk not just about football and darts and karate and other things. They talk about many other things. They talk about their work. And I would not be horrified if I heard Justice Ndau, when you're walking into the airport tomorrow, someone says, "Oh, I saw you on TV. Oh, you're involved in that case of the DA. Oh, okay. How is that going?" And they just have a chat with you about it. The presumption is that it doesn't matter who says what. Your wife or your husband could say the same thing. It doesn't matter who says what. If you're a judge worth his salt, you're not going to be influenced by what people say on the sidelines. That is the key of what judicial independence means. You are independent. And it means that it doesn't matter what the squealers on the side are saying about your case. They can say what they want. But because you are a judge who took an oath of office, you are not going to be swayed by anybody. Your child could come in and say, "I'm a law student. I hear that you decided this case that you're sitting on now. I've done a bit of work on it, and I think you're wrong on this." Are you supposed to then say, "Quiet, don't talk"? Your husband could do that. Just have a discussion with you. The presumption is that you are not going to be influenced by that kind of discussion. And that's what Dr. Hlophe says. He says, you know, my removal from office was based on a conversation I had with about 3 people. I had and he describes the circumstances of the conversations he had. He makes it clear that he did not intend to influence anybody. The witnesses that came there makes it clear that they didn't think that he was trying to.
But unfortunately, we are bound by what is in front of us.
And what is that, my lady?
And that is the findings of the JSC, the findings that led to these impeachment. We don't have anything else. I don't know what the review is about, what is alleged there. That's simply not part of the factual basis in front of us. It's not so that what is in front of us is the fact that he was impeached and the reasons that were given for that decision to impeach. We can't then say second guess that.
No, no one, and I've not made a single submission that suggests that you need to second guess anything about his impeachment. I've made it clear that he was impeached. In fact, I encourage your ladyship to say it. Yeah, I've never said that he was not impeached. That fact stands. It's ugly as it is. It stands unflinching. But what you are being asked to do by the applicants is to do a further thing. They're asking you to impose a further restriction. Not just impeachment. They are not happy with him just being removed from the role of a judge, from the position of a judge. They are not happy with that. They want you to do an extra. They want you to make an order that he cannot, because of that removal from judicial office, he cannot be designated by the National Assembly as a member of the JSC in accordance with Section 1781H. That is why these arguments are being made, my lady. I don't know whether your comment was based on the fact that you believe I'm making irrelevant submissions.
No, all I'm saying is that is a part of the given facts before us.
Yes, and I'm
That's all I'm saying.
yes, and
I agree with that, Dr. irrelevant.
yes, but the submission I'm making, which I hope your ladyship understands very well, because it's a submission that is very critical, is that do not be trapped in the narrative that you need add more punishment than has already been done. Section 178 1H does not permit you to do that. Does not require you to add a bit more on what is there.
Are the applicants not rights as an individual if you get to balance them with the public trust in the judiciary? One of the two must take precedence and the other must somehow receive in the background. If we have to balance the two, the public trust is rights as an individual to earn a living or to contribute to or to hold an office as would have been stipulated by the National Assembly. If we have to balance the two, take into account the public trust in the judiciary and the public confidence in the judiciary, which one you have to take precedence?
I would hate to sacrifice anybody's rights for any public benefit. And the Constitution doesn't allow us to do that. Each person has got a right. Hlophe, Dr. Hlophe has got rights. That rights against the world. Of course, they can be limited. I am accepting that. And your proposition is that public trust could be one of the limitations that we place on these rights.
In the judiciary, that is the one that is holding our democracy in place.
Justice Mbele, here's the answer, the best of my ability, the answer I can give to you. Public trust in the judiciary is very important. In fact, public trust is indispensable. When the public loses its trust on the judiciary, there can be chaos. It can fracture the constitutional order when the public has lost their trust in the judiciary. But here's how the public trust in the judiciary is removed. It is not removed because the applicants say that what they say about Dr. Hlophe. Public trust is not imperiled when members of the public are told that the law of the land say that if you are a member of the National Assembly, you are entitled to sit on any committees of parliament, you are entitled to also sit in on any, to be designated on any bodies of the Constitution for which National Assembly members are entitled to. You have to accord the membership, the status of membership, some status in the suitability inquiry that you are making. Because here is the problem with not making that presumption of integrity to the members of the National Assembly. You're going to inquire into his past, as I say, and you're going to disqualify him on the basis that he was impeached. And you have to say, and I'm sure that the applicants won't be able to accept this proposition. You have to say that his 30 years old, close to 30 years of experience as a judge, must have done he did something extraordinary as a judge president of this division. Working in the JSC, he knows the JSC in and out. He has knowledge of what the JSC is about. What he was impeached for is not of what he did against the JSC. What he did was something he did that had to do with the Constitutional Court judges. And as I said, there is a division over whether what he did was gross misconduct. So I'm saying that, and I'm submitting that, Dr. Hlophe's eligibility to sit in any committee of National Assembly cannot be based on his history. Can't target him because he has a history of having been removed from the bench. Because that, essentially he lost his job, let's put it that way. So how many of those members of parliament lost their jobs before they became members of parliament? I was going to go there and say, well, you lost your job as a member of this, and you lost a job as a doctor, you lost a job as a mechanic, you lost a job as this, and therefore we want to see whether your having lost a job has any bearing on Section 165(4). No. It's sufficient, and it's sufficient because the Constitution says so. That the National Assembly merely looks at one aspect. Are you a member of the National Assembly or a member of the opposition? Have you been nominated by your party? That's the only way they can give effect to 178(1)(h). The only way National Assembly can give effect to Section 178(1)(h) is if they follow the convention that they have followed, which is to say to members of parliament, give us the names of people you nominate from your parties who should be designated by the National Assembly. And of course they're given these names. These political parties are not friends. They are not hacking each other in parliament and having a jolly good time. They differ ideologically most profoundly. Even when they are in the government of national unity, there's a big fight in there. Right? So what then happens is that in terms of the convention, a party puts forward a name. That name is voted upon. And if there's a majority of members, that name goes through. There is no extra requirement, additional requirement to inquire into the person's past, which is what you're being asked to do, to impose. If you want to do that, then you change the law. Change the law. Don't call it a lacuna, because it's not a lacuna. It's clear that the convention seeks to address a difficulty that is presented in 178(1)(h). And that difficulty is these three members must from the opposition. In other words, the majority cannot push its weight and demand that a particular member from the opposition must be the one that they want. The only way you can give effect to 178(1)(h) is through that convention, where members of parliament actually respect the Constitution by saying, okay, the Constitution requires us to have 3 members from the opposition, which tells us as a majority party that we can't detect to the minority who they want to have as a member of the National Assembly. We can't do that. So 178(1)(h) is a counter-majoritarian provision. And this is why that provision is very critical. That convention is very critical and very important. Because you will know that Section 57 of the Constitution gives Parliament the right to make internal arrangements, to determine and control its internal arrangements, proceedings and procedures, and make rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement. The rules and orders of the National Assembly must provide for, and this is like a duty they cannot avoid, the establishment, composition, powers, functions, procedures, and duration of its committee, the participation in the proceedings of the Assembly and its committees of minority parties presented in the Assembly in a manner consistent with democracy. That provision, Section 54(2)(b), fits like a glove in the convention that Parliament uses to designate members in terms of Section 178(1)(h). Because that tells you that Parliament must pass a rule, a convention, a practice that allows minority parties to be represented in the Assembly in a manner consistent with democracy. And then, of course, the 2D says the recognition of the leader of the largest opposition party in the assembly as the leader of the opposition. All I'm saying is that how does one give effect? And this is what Parliament was able to resolve a long time ago, until the DA was not happy with Dr. Hlophe being nominated as one of the 6 members. They were happy to accept that 178 required them to adopt a convention that respected the choice of the minority parties or the opposition parties. Because the Constitution says they must do that. They must pass rules. They must, and here we are told there is a convention in Parliament in terms of which minority members are designated onto the JSC through 178.1H. So the question that one must ask, which cuts across all the arguments advanced by the applicants, is a simple one. Has the National Assembly acted lawfully? And the answer is yes. How have they acted lawfully? They have designated 6 members onto the JSC. And the antecedent question is, are these members of the National Assembly? Yes, they are. Is any of their membership being attacked by any of these applicants? No. Is 3 of those members of the opposition? The answer is yes. So how can it be irrational, having regards to Section 57, which allows the National Assembly, which permits the National Assembly to design its own ways of giving effect to their constitutional obligations, through actively promoting the inclusion of minority parties? Of course, we've heard from the DA's suggestion that, we anybody else but Hlophe. So that's exactly the tyranny that Section 178.1.8 seeks to stop. This ability of a dominant party coming onto another party and saying, we don't want this one, we want that one from your party, or choose anybody else but not that one. That's so anti-democratic. But here is what it does. The entire premise of the applicants, it seeks to get Parliament to act in an unconstitutional way by adopting a convention that is that violates Section 9.1 of the Constitution. And Section 9.1 of the Constitution is very simple. I don't know why Mr. Mpofu and Mr. Butlander don't understand it, but let me elucidate.
They don't understand it.
Well, that's what when he stood up to object, he said, I don't know what MK Hlophe says about it. No.
I'm not so sure. I'm not so sure.
No, he's my brother, so don't worry about it. Don't worry. Yeah, I must blame it on Mr. Butlander. He's the one who tries to mischaracterize our argument. Unsuccessfully though. Section 9.1 is very simple. It says everyone is equal before the law and has the right to equal protection and benefit of the law. That's uncomplicated. I don't know why Mr. Butlander struggles with that. It's simple. It's a tried proposition that requires no elucidation. Everybody is entitled is equal before the law. What they are asking you to do is to look at Hlophe, Dr. Hlophe, and say to Dr. Hlophe, you are not equal. And the reason you are not equal is because your history, you supported apartheid. No, I'm not saying that. But you were impeached. You were removed as a judge. That's why we think there has to be a special law. My learned friend here correctly calls it the Sobuwe provision. A special law by Parliament. When it comes to Dr. Hlophe, special law must be passed. That law must take into account that, hey, this man was impeached. And they say the reason that must be done is because he will do violence to Section 165. It will do violence to Section 165 4 if he's appointed. But let's take that argument a little further. Let's assume that Parliament did that. It went into an inquiry into Hlophe's fitness, which is not necessary, but let's assume they decided, well, the DA is a very powerful party in the National Assembly. It can litigate you and ask for all sorts of cost orders until you comply. They took Dr. Hlophe through that process, called him for an interview, and I'll deal with this obsession with Smelane judgment, which is completely irrelevant to these proceedings. They take Mr. Hlophe, he sits there, they ask him questions. The Corruption Watch would like to hear an apology and a repentance. I mean, the last time his co-counsel said Hlophe must repent of these sins. So the JSC must then have that process where Hlophe sits down and says, "Look, what's your impeachment?" And then one shudders what kind of questions they'll be asking. Do you think that your designation as a member of the JSC, of the National Assembly onto the JSC, is consistent with judicial independence? Those are the questions that the DA would want to ask. But the same question can be asked about prosecutor who resigned under a cloud. Do you think or a teacher who was fired from his or her job as a teacher, or a carpenter, or an engineer, or a CEO of a company? Question is, so let's assume that Dr. Hlophe is able to answer this question to the satisfaction of the interview panel. I don't know what they're thinking of, but they're thinking of something that is unique to Dr. Hlophe. Let's assume he passes that screening process and he is brought on to is designated by the National Assembly. Would the dynamics change? Would it still mean that because the National Assembly took him through a specific process, the judiciary is no longer under threat under Section 165? I mean, we mustn't play with this Constitution. It's very precise. The Constitution will not be threatened by one member of the National Assembly who happened to have an experience with the law in the manner in which President Dr. Hlophe had. It will not be threatened by that. It's an alarmist position which is devoid of the legal reality. The Constitution must now be changed because there is a Sobowe in the House. It's just an incorrect constitutional premise to go. So what must the National Assembly do in order to fulfill its obligations under Section 165(4)? That's one question that we must ask. What must the National Assembly do in order to fulfill its obligations under Section 165(4)? And 165(4) tells us what they must do. (165)(4) says organs of state, let's say the National Assembly, through legislative and other measures, must assist and protect courts to ensure independence, impartiality, dignity, accessibility, and effectiveness of the courts. They must, through legislative, that's the job of the National Assembly. Legislative. And other measures, well, other measures could be who they appoint onto the JSC. But that's entirely up to the National Assembly. It cannot be dictated by anybody who they appoint onto the JSC. So the court must stop this distortion of the National Assembly process. So the National Assembly, in order to support judicial independence, has passed the JSC Act. They've established the JSC Act, and so they have. And the second thing the National Assembly must do is to ensure that the JSC is properly constituted. by designating 6 of their members on the JSC. And the third thing the National Assembly must do is to remove a judge who is found guilty of gross misconduct, incapacity and incompetence. That's how they protect judicial independence. They pass laws, they ensure that the JSC is properly constituted by ensuring that 6 of their members are on the JSC. They remove a judge in terms of Section 177 1B of the Constitution. And finally, they perform oversight duties on issues relevant to judicial independence. So the obsession...
You have 9 minutes before your first session ends.
Yeah, and I have another hour tomorrow, so I'm...
No, it's fine. I was just saying for today.
Yes, no, I do want to carry that 9 minutes through, because there are certain things I still need to say, which I haven't said. So the applicant's main focus on Section 1, on the National Assembly's Section 165 obligations is narrowed to the Section 178(1)(h). They narrow the National Assembly's obligations towards 165 only to 178(1)(h), and only to Hlophe. Only Hlophe is the main concern. Remove Hlophe from this, we won't be here. And FUL will not rest until that happens. Well, and the DA. So the proposition I want to make is this, that the members of the National Assembly must be qualified, their suitability is centered on being members of the National Assembly. There's nothing more that one needs beyond that issue. Because what the applicant's approach would do is to then ask the question, what exactly is required for a member of the National Assembly to be a member of the JSC? Should they have legal qualifications? Should they be a lawyer, albeit with a past, never practiced before? Should they be, what exactly are these qualifications beyond just being a member of the National Assembly? Because this can't be just an issue applied only to judges who are removed from office. Because not only judges removed from office are enjoined to protect judicial independence, even carpenters or teachers who are removed from their teaching posts, who are now members of the JSC, are enjoined to protect judicial independence. The duty remains static. And the duty is not for an individual. The duty is for the institution of the National Assembly. So the point we made of Section 9(1) is that the applicants would have the National Assembly adopt a law that violates Section 9(1), in that law does not place Dr. Hlophe equal before that the law. So 5 members of the National Assembly don't have to go through this law they're talking about, and they would not necessarily be protected by that law. There has to be a separate procedure or substantive law or substantive procedure. There have to be a separate procedure or a law that excludes judges who are impeached from participating anywhere in the judiciary, even though they are no longer performing judicial functions. And then the other point that I raise is that the applicants do not attack the JSC Act on on the basis that the Act does not prohibit, does not add collateral sanctions or collateral consequences for a removed judge. And one must look at the Judicial Services Act. The specific provision that deals with sanctions, and that would be section 17, section 17(8) of the JSC Act. And that act says, that provision says, anyone or a combination of the following remedial steps may be imposed in respect of a respondent who's been found guilty of misconduct, but that the nature of which there is no impeachment. They say you can apologize to the complainant in a prescribed manner. You can have a reprimand, a written warning, a form of compensation. I remember one judge was required to pay 1 million rands as a compensation or some kind of. Yes. And then appropriate counseling, attend a specific course. I'm saying this is where punishments are meted out. They are set out there, at least for this kind of offences. But for removals, and I will come back to what Mr. Padlenda tried to submit erroneously, my aid to that. For removals from office, where the sanction is removal from the office, the JSC must simply put through its secretariat, give the Speaker of the National Assembly the ruling of the JSC, and convey to the Speaker that that's the finding of the JSC in terms of section 177(1)(a) of the Constitution. Now, Mr. Padlenda started off by suggesting that we want a JSC that is not based on experience. One of the issues he suggested was that we are saying that experience does not matter. And then he also suggested that he spoke of a pedophile.
He doesn't say that experience does not matter. He actually said.
We say the experience doesn't matter.
Oh.
That's what he says. I mean, he will correct me if should I ask him?
No, it's fine. You have to say.
Okay, so we say suitability does not matter. But then he gave examples. The example he gave was one of a pedophile, and then the other one was what? A judge who is removed because they took a bribe. Now there's a simple answer to those two propositions. Simple answer, and one must just acclimatize themselves to this law, man. This law, this Judicial Services Commission Act 9 of 1994, Section 32 says, if the tribunal, the Judicial Conduct Tribunal, is of the opinion that evidence before the tribunal discloses the commission of an offence by the respondent, the tribunal president must notify the National Director of Public Prosecution accordingly during or after the hearing, and cause a copy of the record or the relevant part of the record in question to be submitted to the National Director of Public Prosecution. So if, for example, the evidence comes across that there is a bribery involved, that's a criminal offence. And the law says that where that has happened, this is how it's going to be dealt with. No one is suggesting that a pedophile or a corrupt judge in the nature of Padlenda's example should serve on the JSC. No one suggests that. In fact, what Mr. Padlenda did not miss there is that even this person who's been found corrupt and is sentenced to jail for 14 years, when they get out of jail, after 5 years of getting out of jail, the law says they can be members of the National Assembly. And once they are members of the National Assembly, they are entitled to the benefits of membership. And if they run a party, they are president of the party, they can be nominated to be on the 17818 panel So Mr. Badlena mischaracterizes the entire premise is faulty.
Nominated Chief Justice
Yes.
of the country.
Let me end here. For today.
And your time is up for today, yes.
Yes. Let me end here, Judge President. Let's assume, and it's not a dream too far, and we will live to see that in our lifetime. Dr. Hlophe one day is nominated by his party to be president of the country. I mean, I know it horrifies certain people here. I mean, it just takes them to another level.
You mean beyond Mr. Zuma's lifetime?
Beyond Mr. Zuma's lifetime. Let's say that happens. Dr. Hlophe is nominated as president. The DA will be here in court, making the same arguments they're making. Because it is a president who appoints judges. It is a president who actually terminates the employment of judges. They are going to be saying, no. We can't have, in fact, in accordance with the DA's senior counsel, who is my friend. So I must say this knowing that he's my friend, so I don't lose this friendship. According to this friend of mine, Mr. Jamie, this is how he puts it. He says, it's just I wrote it.
Tomorrow morning.
We cannot allow someone who has been removed from office to sit on the JSC. And of course, it's a Section 165 argument that they are advancing. What are they going to say when Dr. Hlophe is President of the Republic of South Africa?
If I wasn't for vote.
No, I'm just. We have to work with. You see, because when they talk rationality of the National Assembly's powers, one has to look ahead and see whether this judgment they're asking you to make is not a judgment that's going to cripple the fluidity of our constitutional system. That the National Assembly makes decisions it must make, and the others do not. And in paragraph 97 on page 3866.
But your time is up, Mr. Masood.
Oh, just this 1 minute. Just this one minute. Please, just 1 minute. Paragraph 97 of Judge President of Dr. Hlophe's affidavit, page 3866. He says, I reiterate that in my many years as a judicial officer and head of the Western Cape, I found the culture of judges interacting with one and with others to be normal and necessary. There is no evidence that judges who make private comments on pending judgments compromise judicial independence or amounts to interference with their judicial functions. That's the paragraph that I believe Justice Ndau wanted to have been referring to. I am forced by the affliction of time to stop, but I could continue if the court allows me.
No, not today, Mr. Masood.
As the court pleases, my lady.
Thank you. What I dance with the day
Thank you. That's what I was doing.